There's the thing with these vintage ones, ne? Gents don't know, but the vintage ones,
You must understand the value in something before you sell it. That's why I don't think I'll ever be. I
bands.
don't think I'll be able to sell my IP, bro. Like
Never.
something that I'm like so invested in that I own. I can't do it, man.
Because at some point it's gonna just skyrocket. That's what happens with IP.
It's always gonna
If
be
you
worth
have it
something.
for long enough, ne, the value goes up.
It's always gonna be worth something to
It's
somebody.
always, bro. Always.
No ways. All right.
50 bands.
50.
50 bands, bro.
The second there's more than 3 zeros after the number, man, I'm excited. I want to find out what's happening.
50 bands, bro.
Okay. Welcome to the Blackbox series here on the Astrowave Network. I'm your host, Sibule Zugufa, and I'm joined today by a very special guest, a newly appointed chief in the Kwe Royal Tribe in the Northern Cape, a corporate law specialist, a tier 1 operator in the fields of art. He's a public speaker. He's anything you need and everything you need. His name is Kevin Smith.
Appreciate it. Thanks for having me once again.
Show, cuz.
Appreciate you.
Watch the stay in this item. As you know, as I just said, Kevin is a corporate specialist. So for the people at home, let's give them a little background. And can you tell us your copywriting journey?
So I'll give them a full background of my whole professional career, in fact.
Yes, sir.
So as you mentioned, I'm an attorney. I'm a partner of my law firm, AGA Incorporated. I made partner when I was 26, something that people usually only get in their late 40s, you know. Prior to that, I was internal legal counsel at a political party. I won't say which one for now.
Yeah, let's allow that. Let's allow that one.
Yeah, and through my legal journey, I've actually been fortunate and blessed to have got a lot of work done in the entertainment space, in the art space as well. So I've managed to actually infuse my love of art and law during that journey and the subsistence of the work that I've gotten. So with that being said, that's actually how I got into the copyright space, because I got into entertainment law through the contractual aspects of it. And that actually opened the door for me to see that copyright, being something that's very underdeveloped in our economy, is something that I need to take responsibility of developing. And the reason why it's underdeveloped in our economy is that our economy doesn't run on the basis of entertainment and copyright like it would in the United States, for instance, where they have an economy for over the last 100 or so years. They've actually mastered the art of packaging copyright, packaging protected works, and actually selling that not only domestically but internationally as well. So it's become a viable product for them, and also a way of generating soft power throughout the world. So it's something that I felt that I needed the responsibility to develop in South Africa, so we can actually emulate what other economies have done. So that's how I got involved into the copywriting space. I managed to actually get a further qualification in copyright. And that's how I started to see that there's a lot of synergy between copyright and AI. Because what AI is actually doing is AI is producing protected works. And for the most part, it's producing infringing works. And that's something that a lot of people, even in international jurisdictions, don't understand currently. They don't understand the implications between copyright and AI, and what in fact AI is infringing when it creates new works.
All right, okay. As he just mentioned, AI, and that is the topic of today's class. You, the viewers at home, and myself are all going in blind. Kevin is going to share some of his insight and educate us on some copyright issues in relation to AI. So, let's ask this first question. AI, pretty much, if you have a smart device, you've seen some shape or form, either a song remix where you've got Kabza Small and, say, Psy, who does Gundam Style, making a remix. And it sounds so authentic, you know what I'm saying? But that song actually doesn't exist. So with it shaking up the game like the way it is right now, how does that really affect copywriting?
So it's actually very important that you've made mention of that type of example, because AI is not a new thing. You know, AI and algorithms have existed from the inception of computer technology, from the beginning of computer time, essentially. Something like predictive text in your phone uses algorithms and AI, because it has to predict an outcome and then it has to actually produce that outcome. Now, with the music example that you have actually given us, there's a lot that goes into that. Because for the first part, there's an impersonation of those artists that actually exists. And that's one issue of illegality there, because if you look at it in the aspect of the United States jurisdiction in particular, there, if you have an impersonation of a musical artist or an impersonation of a musical work, that is its own specific infringement. Now, a similar example to that, there was a song released, I don't want to say released because it was infringing, but there was a song created recently that impersonated Drake and The Weeknd.
It was a banger also.
Was a banger.
It was a banger.
And that was actually taken down. But it wasn't taken down on the basis of copyright infringement. It was taken down on the basis of impersonation. Now, that's something that the viewers need to actually understand, is that there may be an aspect of copyright infringement, but legally speaking, it may be easier to follow the avenue of impersonation to get something taken down. So you'll see if you try and search for that song now, it's been scraped off TikTok, it's been scraped off the net, it's been scraped off social media on the basis of not just copyright infringement, but impersonation of a musical act.
Okay.
Right? Now, if you look at the copyright aspect,
Keep playing, boss. Keep playing. Oh, we're gonna pause when there's loud noises. So.
okay. So when you look at the
Okay.
So when we look at the aspect of copyright infringement of an AI-generated song,
Cool.
So when we look at the copyright aspect of an AI-generated song, we need to differentiate actually between the song itself and the infringing part of the song. Now, viewers may think that by virtue of the fact that the song was generated, that's the illegality. But that's not necessarily the case. Because like I said, the output being the song itself, the illegality there could be impersonation. But the actual infringing copyright could be deeper than that. Now, with AI software, there's this thing called AI training and machine learning. So the AI doesn't understand what it is doing, nor does the AI particularly know what it is doing. If you tell it to generate something in the style of Drake, it doesn't know who Drake is, doesn't know what Drake does for a living. So you have to feed it a lot of Drake's information exactly in order for it to establish that if I see a cadence in this aspect, or if I see song lyrics that go in this way, if I see a flow that flows a certain way, that equals Drake. So then you have to feed it sufficient information for it to be able to itself create an algorithm or to create a pattern that it can then replicate. Now, the information that gets fed into that AI software could be where the copyright infringement comes. And that is because you are feeding it protected information that it shouldn't have been fed in the first place, because that information may be in the public domain, but it may still be under copyright protection. Now, the reason why that's an issue is because it then becomes an unauthorized derivative work, where it's an unauthorized usage of that protected work in order to generate that AI software. Not the AI software, but the AI song. The further element of that is whether that song is going to be used for commercial purposes or not, if it's going to be used for educational purposes or not, because then it may fall within fair use. But for now, it suffices to say that those are the two aspects of copyright you need to look at: the impersonation of the musical artist and their musical style, and then further, where the protected information was used to train that AI model.
Okay. I'm glad you mentioned fair use, because we're going to get into that a little bit later. But with the creators consistently fighting for ownership rights, whether it's musicians, more distribution for their deals, or things, there's always some form of a fight when it comes to trying to get your creative work in your house. So when you say there's an output, I mean, you got to give the machine something, it processes and produces something. But now, when that work comes out, who do we create and give credit for that? Is it the... Okay, let me try this again. So you say the machine has to be fed information, it processes, and then it gives us an output. But now, say you create something incredible, who's responsible for that? Is it the creator, or the person who built the AI, the user, the person who uses the platform, or the creation itself, which is the artificial intelligence itself?
It's a very good question. And the reason why that question is actually important is because, like you've mentioned, there are three parties that are involved in that whole process. Now, with copyright law and copyright protection in particular, there's this thing called authorship. So you need a valid author in order for the authored work to be copyright protected. Usually when you look at domestic legislation and if you look at the international conventions, that author usually needs to be a human being. Now, when you look at AI generated works, the author in that aspect, for the most part, will be the software. And that's because the user doesn't creatively align or creatively mix or creatively join certain information to create that work. All of that is being done by the software. The only thing that the user does, it gives it a prompt. Now, that prompt isn't sufficient to be seen as authorship. Now, when that happens, the AI can never create any copyright protected work because it can't be seen as an author in the first place. But deeper than that, when we look at what the AI actually used in order to generate it, if the AI took protected information in order to then create a pattern that then creates the work, the protected information is already a part of copyright infringement. And that copyright infringement means that you can't then claim ownership, authorship, or have copyright protection because you have already produced an infringing work.
Okay.
Now, the other question which still needs to be ventilated in the courts, because this is a very new area of law, is if my work, my protected work has been used in order to produce an infringing work, can I then claim that as a derivative or not? Now, we then have to also look at things like the moral theory, if the work is within the confines of that doctrine within itself. But as more cases get ventilated in the courts, we'll see whether or not the question of can someone claim it as a derivative or if they can claim it as just infringing, if that's going to be the case. But as it stands now, to the extent that protected work is being used, for instance, like if Drake's previous album is used to then create a new album, which he has no involvement in, that would be an infringing derivative work. Because number one, he hasn't given them the authority to use his protected copyright in order to generate that work. Nor does he get attributed to that work, and as well as an impersonation aspect. So once those three aspects get ventilated in courts, we'll have a better understanding of where the law will take it going forward.
Okay, we spoke about the moral theory. I'm looking at the rights and respect. So humans are socially accountable, well, hopefully, for their actions. So if I go on Twitter and I behave like a horrible person, I'm expecting to receive some backlash. But if maybe I create a social media page that produces memes only, and I use AIs to produce those memes, but the material that consistently comes out of there is offensive, but I have AI running that page, would I get an excuse? Would it be excused because it's artificial intelligence? It doesn't quote unquote qualify as an author?
No. And the reason for that is that firstly, if it's offensive, but it is breaching the terms of use of that platform, that will always apply. So the beautiful thing about the law is that the law is structured in a way where certain things are protected regardless of who it is doing the infringing. So when you sign up to any particular social media platform, you have to accept its terms and conditions. Now, if the content that you are producing breaches those policies, you will be in breach whether or not you used AI to generate the content or not, because it's still your page. Now, the other thing also then comes in is the memes or whatever content it is that your AI is producing. Do they then amount to copyright infringement or not? Because like I said, copyright legislation and copyright law would apply regardless of whether it's produced by the AI or produced by you as a human being. The fact that you have taken it and then put it on your page, you are still accountable. If you are then also monetizing that page or trying to make commercial use of the page, then you're even more liable because there's an intent or a commercial intent that is involved in that. Now, things like fair use would only come in if, for instance, you're producing something that is a parody. The memes could be a parody of real life situations. That could fall under fair use. It could be educational. That could be under fair use. But then we would also have to look at to what extent and what the purpose of the content would be. And like I said, we then need to see if there's a commercial tie-in and if it breaches any other legislation, whether it is the terms and conditions of the platform or if in South Africa, if it breaches our Bill of Rights or our constitution.
Okay, some people would use. Okay, we mentioned fair use. This is something we see everywhere on particularly YouTube. Content creators put it up in front of their posts, especially when they're going to show material that is either not theirs, like say some rugby highlights or movie clips or things of that nature. Can you please break down fair use for us so we have a better understanding of what it is?
So fair use as a doctrine essentially is used to allow you to use protected material, but you won't be liable for any copyright claims, royalties, or license fees. And the reason for that is that fair use allows you to use protected material for your own personal use, for religious purposes, for scholarship, or for research. Now, when you look at intellectual property law as a whole, intellectual property law as a whole is essentially just different business models that have been codified into the law. To the extent that fair use is used, especially in YouTube, you'll see that fair use allows someone to actually take protected material and use it for purposes of news, for criticism, or for fair comment. Now, because that is the confines of what fair use allows people to do, it created its own business model within YouTube, which is why you actually see that there are a lot of reaction pages on YouTube where people take protected highlights, like you've said, and then they give their reaction or they give a comment. That is just an insight as to how the law itself, or the confines of the law, creates different business models within the IP and entertainment space. Now, what that actually allows you to do is, you take, for instance, like you've said, an F1 highlight, which is something that is done on one of your other pages as well, and you guys give your own commentary and reactions as to what's happening. But it has a further element to it, and that is that you can only take portions of it. You can't take the entirety of the protected material and then create your own copyright protected material, because your reaction to that has its own copyright protection. So the footage you then generate also has its own copyright protection within it. So you have to take a portion, because what the law does is that it looks at to what extent have you used the copyright protected material and for what purposes. So it can't be done for a purely commercial aspect where you take it and then you essentially repurpose it and copy it into your own format so that you can then have a commercial tie-in. It has to be within those confines that fair use allows you to do.
All right. So, like, if I were to ask you a question, remember the Touch It remix with Busta, where he had about 6 or 7 editions of those things? So, if I was like, I really, really want a part 8, but I want Celine Dion, Stevie Wonder, and maybe Brandy to feature in on the verse, and I use AI to get that, but I credit it to Busta. Am I skating on thin ice there, or is that something I could potentially play around with?
You've actually fallen through the ice a long time. And the reason for that is that
there's already 6 editions, and I'm just coming up with number 7.
The thing is that Busta Rhymes is the original owner of the copyright. So he has the right to reproduce it, right? So the remixes are his own reproduction. The featured artists are then just co-copyright owners because they've attributed to the new copyright. So each edition is its own new form of copyright. So remix number 1 has its own co-authors, because it would be him, Missy Elliott, Swizz Beatz, whoever the case may be. They then have their own copyright claim in that one specific song, because there'll be a royalty tie-in, there'll be licensing implications. Now, to the extent that you make a new one, you're creating a new copyright protected work. And if you are featuring other artists, if you haven't got the authority to use their name and likeness, that's an infringement. So even though you've attributed back to Busta Rhymes, there are still those other artists who have their own legal claim to the song as well. And then who would the royalties go to? Are they going to you? Are they going to those artists? Are they going to Busta? Busta has to give you the authority to use his song in the first place. Those other artists have to give you the authority to use their name and likeness. And to the extent that AI software is used, they give you the authority to use their previously protected works in order to generate the new work.
Okay. Damn. Hardcore. So, if anyways, there's no freedom to just take it. I can't just wake up, make a cover or remix of something. And a fear that some people would probably have is the enforcement of such things. But we mentioned the public domain earlier. Some instances might have licenses that have expired, or maybe they're in the process of being renewed. So if it uses public domain data, when you mentioned area, is there a gray area there where I can say, but this was free to the public, this was free to the public, but the result, the output I got, maybe it looked like Beethoven's face, and then somebody on Beethoven says, no, I want to claim that, but I say I use public domain. Is that a sound defense, or is that just hogwash?
Definitely. And that's actually a very important aspect, especially when we're looking at AI going forward. I'll give you an example that recently has taken place. The New York Times, they've placed in their website terms and conditions that explicitly states that you cannot take any of its protected data in order to train any AI model. What that actually means is that they're taking their data out of the public domain. Reason being is that if you've used public domain data, there's no copyright protection in public domain data in the first place. So whatever the AI software then generates, now because it doesn't have any infringing elements to it, whatever then gets produced, you have copyright protection within that work, whether it's a literary work, musical work, artistic work, whatever the case may be. And that's on the basis that there's no infringing components to it. There was no infringing protected data used in order to train the AI model, meaning that it can't produce something that is infringing, because all the information that it's used to train itself is free for it to be used. You have authority to use it. The only issue then comes in is if there would be a protective element. So that would be if you prompt the AI software, the AI model, to produce something that could look like a derivative work or an impersonating work, or could have other implications. So in the Beethoven example, if Beethoven's estate, because he's obviously dead, he doesn't have any power over his image rights. If to the extent that his estate has ownership of his image rights and they have certain restrictions on the use of his name and likeness, that is a specific infringement in that particular example. But public domain is public domain. If something is generated from the public domain, it doesn't have any protection. Even if AI uses public domain information to create works, there's no protection there because it comes from the public domain itself.
Banger. Okay, I want to look at it globally now. All right. As we live in a multi-diverse world, different countries have different laws, especially pertaining to copywriting, banking, whichever flavor sundae you prefer. So now with AI being everywhere and anywhere, I know you mentioned some frameworks or conventions that have been put in place. How do we keep it 100? How do we keep it on the straight and narrow? Could you expand a little bit on those interventions or conventions you mentioned earlier?
Yeah, so we have what's called the Berne Convention and the TRIPS Convention. So those are actually international treaties that were signed by various countries worldwide for that particular purpose, in order to streamline not just copyright, but IP laws, so that we don't have the jurisdictional elements of legislation stopping either copywritten works going globally or copywritten works being used globally. It doesn't necessarily mean that it stops any particular country from having their own legislation. We in South Africa have our own Copyright Act. The United States has a Copyright Act. Most countries have their own domestic legislation, but what the Berne and TRIPS Convention do is that they give you guidelines to help you then draft your internal legislation, so that it doesn't then go outside of the guides and the bounds of international convention. So those international conventions actually give some form of uniformity, because with the advent of those treaties, they understood that things like copyright have a global impact. You're not going to produce music just for your domestic markets. It is going to go further. And like I've said before, there are economies that are actually very developed in those aspects. And that is what actually goes into these treaties being drafted in the first place, is that they knew that our copyright protected information has to move between jurisdictions. And we don't want too many hurdles between our jurisdiction and the next jurisdiction in order to make that happen, because then you will be cutting back on the commercial tie-in. And remember, like I said before, IP is basically just to allow you to make use of certain business models. So if your internal legislation stops me from doing that, then it's cutting back on the commercial time that I may be able to have by producing copyright work.
This is what they teach you at those Harvard courses. those UCT courses, that's what they teach you. Okay, we see you. Right? We want to get into the future of this thing. We've talked about infringements and how we can circumnavigate, but there's always two sides to a coin. We've gone negative. Now let's look forward. All right. There's obviously potential for business here. Potential for new markets to develop. And in your educated and expert opinion, how do you see the game evolving? How can the game evolve to accommodate AI?
The thing is that us as creators, we need to take responsibility of where AI is going forward. The way that the law is structured is that the law needs the industry itself to play some things out first before they come in and regulate things. You'll see that before any legislation gets enacted, a few things have to go through the court system so that the legislators and judges and lawyers like us at large understand, okay, these are the problems that creatives are facing. But if we look at this going forward, let's look at music that we've spoken about already. I, as Drake, or I, as Jay-Z, I could take ownership of my likeness, my flow, my style, right? And I can actually then allow AI to generate new albums or new collaborations on my behalf, and I take a royalty from whatever is generated. So he can put a disclaimer, he can put something in his T's and C's on his album saying that AI is allowed to generate new works, put the parameters in place as to what those works can be, and this would be the share percentage that we have between what the software generates and what royalty he would take.
Okay.
So when you see things like when Jay-Z says, people want my oldish, buy my old album, I can then make a similar to his old album using the cadence of his old album, using the subject matter of his old album. And then I can still get that experience from Jay-Z, so then I can subscribe to an artist in that manner. It can even go as far as acting. Recently, what has happened is that J-Lo, she did an advert based entirely on AI, where it seems as though she's in the advert doing the acting and doing the advertising, but it's all AI generated, So that's her digital twin. So what a lot of people can start doing, especially actors and models, is that they can make use of a digital twin so that that digital twin can go out and do those commercial gigs, do those advertising gigs, or even do acting gigs while they're on set in another place. So then that vastly increases your earning potential.
Okay, it's very important. They actually did a Black Mirror episode specifically speaking to digital twin, as you would call it. And if you don't know, the SAG industry in America is currently on strike because they want certain protections from AI. But in terms of business, you speak about having a digital twin. I would personally like to be able to be two places at once, to be able to do two things at once. But there's a danger there of how things can quickly spiral out of control. I mean, I imagine that the deal would have to be updated regularly, because I know when T.I. was sitting on a podcast once where he spoke about, he looks into the idea of leasing out his catalog versus selling it, like maybe a Dre did for close to 200 million. So he leases it for a period of time, earns it, and then it comes back to him. Do you see that as a potential viable option? Is okay, you know what, for 5 years you can make AI material for me, but after 5 years that has to stop. So basically the question I'm asking is, how can this relationship grow between the creators, the creator, and the user itself?
Now, if we look at T.I.'s example, that lease will have parameters as to what he would allow them to do with his catalog. So contractually speaking, he would then set the parameters as to, this is the type of information I'm giving you, this is what you can produce thereafter. The same thing can be done with a digital twin, because it will have to be appointed via a contract in the first place. So if I, as any advertiser, say I need your digital twin to do an advert for me, it will be on the same lines as if I was doing it in person. I would still have to sign a contract. I would still have to say, this is what I'm willing to do. These are the things that I'm willing to say. These are the things that I can't do. So then you can't have your digital twin doing something that's racially insensitive or sexually explicit or goes against your personal brand. If you look at these types of things, right, you can have situations where people subscribe to a particular actor or a particular model. And not a lot of people actually understand this, but one futurist in the United States, her name is Sinead Bovell. Shout out to Sinead, actually. She's actually brought the conversation forward in terms of a digital twin being subscribed to. So if you are an actor, for instance, if you are Morgan Freeman, I can subscribe to you as Morgan Freeman. And then what can happen is after you pass away or you're no longer acting actively, right? Then AI can produce a series where I can say, I want Morgan Freeman as the lead role. This is going to be what the series is based on in the style of The Sopranos, whatever the case may be. And then AI will generate that series for you. So then you have tailor-made content with the people that you want to see in there, following the storylines that you want to see. But then that actor still gets compensated for the digital twin being there. The actor makes sure that it doesn't infringe on his personal brand, or it doesn't do something, like I said, racially insensitive or anything along those lines. So the business opportunities that open in the future are actually quite vast, where we can have access to specific individuals, specific entertainers, artists, creatives, in ways that are generated and that are tailor-made specifically for our tastes. But then those artists and those entertainers need to take the responsibility of saying that these are the parameters in which I'm being allowed to use that particular person's name, image, likeness, performance style, whatever the case may be.
Correct. We've talked about infringements. We're talking about business. We've talked about the future. All the things you've mentioned to me have spoken to unlocking the potential or the limits of the imagination. Now, as you said, creatives have to take responsibility, but this is really a journey where everybody needs to go hand in hand. Otherwise, it can go sideways very quickly. So for tech enthusiasts and for potential creatives or guys coming in or looking at investing or exploring the AI industry, what do you have any suggestions or recommendations or any insights you can share with them about what world they're walking into?
You see, the beautiful thing about AI right now is that it has limitless potential, you know, not just in the creative space, but for the world in general. But when we look at creatives, the first thing that creatives need to do is creatives actually need to understand what rights they have. And that's been something that, historically speaking, creatives don't educate themselves on. Before the advent of AI, creatives already didn't know the difference between copyright, trademarking, patenting. You understand what I'm saying? So that was already used to their disadvantage. That's why you would have in the music industry people signing 360 deals where you don't have any use of your copyright, and then at the end of the day, you find that some of your biggest artists are still broke. And that's because their copyright is being exploited. Now you're seeing people like Justin Bieber, Future, all of them selling their catalogs and selling the rights to their catalogs for large sums of money. And that's just because they understand the monetary aspect that their copyright contains, not just currently, but going forward in the future as well. And that's the first step that creators need to do. Creators need to start educating themselves on not only the rights that they produce as creatives, but what are the monetary benefits and what business models that they ties them into. Because AI is not going to become its own business model. It's just going to make existing business models either more efficient or expand them. So once you understand the industry that you are in, you can then see, okay, what will AI allow me to do in the future? Is it going to make me more efficient? Is it going to make my creative output increase? Or does it mean that I'm going to be left out of the market completely? That's when we can start having discussions in terms of what regulators need to do, what legislators need to do, and what the law needs to do in order to regulate. Because if you ask lawyers to do that on behalf of creatives, a lot of them don't understand the industry as intimately as those creatives do. So we'll end up regulating those spaces to an extent that doesn't benefit anyone. It's going to benefit the law from our theoretic perspective. And I think that's what's been a benefit for me as an attorney, is that I'm actually an artist as well. So my understanding of these industries is a lot more intimate than most lawyers, even in the entertainment space, ever will have, because I've been on both sides. And that has allowed me to actually have the insight that we discussed now, is on the basis not just as a lawyer, not just as a businessman, but also as a creative. And hence why my advice to creatives is that understand your industry first and foremost, and then understand what AI can do, not only for you, but for the industry at large, so that you play a part in that being regulated going forward. Because while things are unregulated, we have the advantage of actually setting out and changing the gray areas into black and white, where we say that we can actually allow AI to do X, Y, and Z because it will give us a better earning potential, or it will give us a larger exposure to the market, whatever the case may be. But if you don't understand the mechanics of your industry, if you don't understand the mechanics of your creativity, then whatever gets regulated won't be to your benefit in any event.
You heard it here from the man himself. So for the people who are exploring AI options, please do tell the people at home where they can find you, my brother.
So you can get hold of me on all social media platforms, agent_K Smith. You can email me at kevin@againc.co.za. And whenever you guys need to get hold of me further, all of my links will be on the platform. My website will be on the platform as well. Make sure to like, share, subscribe. Get this thing as far as possible. Make sure all of your creative friends know that these conversations are taking place and that people like my brother over here are trailblazing in this aspect.
Right. Chief, it actually feels good to say that and actually mean it. Thank you for your time. It's been a pleasure and a privilege. This was the Blackbox series on the S-Wave Network. I've been your host, Subir Zukufa, joined by Chief Kevin Smith. And we'll see you when the sun comes back around.